Hi, everyone. My name is Marcos with Probate and Trust Realty Group. And today we will be doing a podcast on the differences between a living trust and a will. And today we have a special guest here, Narcis Brasov with Brasov Law, to go over the differences between a living trust and a will. Welcome to the show.
Thank you. Glad to be here. And it's such an important question. So many times people think, well, hey, I got a will, I'm good. My kids are set up. And what they don't realize that all a will is telling the probate judge what to do. It still goes to probate court.
Wait a minute. So you're saying that because most people think that a will, you're done, you don't have to worry about probate. Why does it go to probate?
Again, all a will does is instruct the probate judge how exactly you want things distributed to your kids or to anybody else. If you want it to not go to probate court in the first place, you have to have a living trust. And so the way a living trust works, it's like a basket where you're putting your house out of your hands, out of your house, your goods, your accounts out of your hands, and you're putting it into the basket. When you pass away, your kids pick up the basket and distribute what's in it. And it never goes to court in the first place. The idea is that you have complete control. While you're alive, you're in control of what's inside and outside the basket. You can put the house in, you can take it back out and refinance. You can sell the house. You can give it away. You can put a bank account in or out of it. The way a living trust works is you keep complete control. Imagine on the basket, there's the instructions taped on the front, but you're the one carrying the basket. When you pass away, you put it down and somebody else picks up the basket and they read the instructions on the front and they pass it out to people. But it never has to go to probate court. And so why is that a big deal? Because probate is very expensive.
Okay, so for some people that may not understand what probate is that are watching the podcast today, how can you quickly describe what probate is and how it affects their estate and how much it costs?
Sure. It's a court process. You go in front of a judge, and the judge determines, based on California law, how your estate is distributed. It's not true. A lot of people say, well, it's going to go to the state. That's not true. It'll still go to your kids. It'll go to your closest family members if you don't have kids. But it's not that you need a trust so it doesn't go to the state. You need a trust so it doesn't cost so much. Probate is done by percentages. 4% of the first 100,000, 2% of the next 100,000, 1% of the next 800,000, 0.5% of the next 9 million. So, for example, the attorney's fees on a $1 million estate is $23,000. The kid that's in charge also gets the same as the attorney, another $23,000. That's $46,000.
What do you mean the kid that's in charge?
The family member, it's usually a kid, that's in charge of the probate. So they meet with the attorney, they represent the estate in front of the judge. They are the family member that is the personal representative or the executor of the will, for example.
Okay,
all that to say is that it's very expensive. So for $1 million, $46,000. If the kids don't have that kind of money in the bank, they're not keeping the house. They're selling the house to pay off the attorneys.
Okay, so then what you're saying is the personal representative is the person that's selected by the court or that to administrate the estate?
It's selected by the court if there's a dispute, if more than one kid wants to be one, but it's in order of priority. So if there's a surviving spouse, they'll always get first dibs. Then a kid will get first dibs over an aunt or uncle, for example. So there's a whole list in the probate code as to who gets first dibs.
Okay.
But it's a job that people want because you get paid the same as what the attorney makes.
Wow.
So it's really double the fees. The attorney fees are expensive. Jeez. You just double it now for the family. And the problem is not that the kids aren't going to get it. The problem is the kids aren't keeping the house. Most of them don't have that kind of money sitting in their bank account.
Yeah. So then the attorney gets $23,000 and the personal representative gets $23,000, total $46,000. And then there's additional court fees as well. I think
there could be additional fees if everybody doesn't smile and nod and shake hands. As soon as one person throws a fight about anything, then it goes to the roof.
Okay.
This is assuming everybody's completely peaceful, everybody signs off, no problems.
Okay.
As soon as one person says it's not fair, forget about it. Then it goes crazy.
Okay. And then what's the time frame to do a probate case? Is it take 6 months, a year? Or I've heard people say it takes 2 years.
Depending on what county. Orange County tends to be between 18 months and 2 years. LA County, you're pretty much guaranteed to at least 2 years.
At least 2 years, start to finish. And
Yeah.
and that's in a seamless probate scenario?
That's if nobody complains.
No one complains.
That's everybody signs everything. Everybody does the job all the time. Yeah, 18 months is the shortest I've heard for Orange County. Again, LA County,
Wow,
probably
okay.
2 years at least.
And so it takes 18 months to 2 years to sell the home, or are they able to sell the home prior to that while they're in probate?
Oh, no, good question. You sell the home pretty quickly.
Right.
It's the court deciding how everything is distributed and all the debts paid off. And it's actually not so much the court process that takes a long time. What takes a long time is getting a court date, right? The courts are impacted, right? There's a lot of people. Half of Californians die without even a will.
Right.
Forget a trust. So there's a lot of people, and there's not that many probate judges. So it's not that the process takes a long time; it takes a long time to get on their calendar.
Right, right. And the reason I asked you that is because that's a question we get a lot. They say, well, I can't sell the home until my probate case is over. And we always let them know that there is an option to sell the home once they get approved by the court as the administrator or the executor. And some of the pros to selling the home during the probate cases, number one, if they don't have the money to pay the attorneys and everything, then they have to sell the property to be able to, compensate the attorneys. The other reason we let people know is that, a lot of times people, they inherit the mortgage and the debt of the estate, right? So you're here, you're minding your own business, and then someone passes away, and then you get this estate that's dropped on your lap, and you got your own personal life, right? You got your own mortgage, your own bills, and now you got to take care of this other estate. And if there's not a lot of money in the bank accounts, then they have to cover the mortgage.
And what's really important about that is two things to remember. Yes, federal law requires banks to let kids assume the loan. You don't have to refinance. That's federal law. However, the property tax goes up. So that was the effect of Prop 19 that was passed in 2020. It came into effect February of 2021. Any child that inherits an interest in property from their parents, it's not on the same tax basis as the kids anymore. The parents paid their property tax really low because they bought in the 80s, 90s, 70s. Now the kids get it, and it's reassessed to 2025 value. Unless they move in within a year of the passing of the parents and they live there. Okay, but if you have your own life, your own house, family may not be really feasible to move in. The property tax goes up a lot. And so a lot of people think, well, we'll just keep mom and dad's house. We'll rent it out. It's paid off. Well, you're going to have to really think about that. Is that a good business decision? Because you're not going to get nearly the kind of money that mom and dad could have gotten, because the property tax will be so much higher, 5 to 10 times higher. It's really going to eat into the rental income. It may be worth it, maybe not worth it, but you have to look at the numbers. Don't just assume I can keep the house and rent it out.
And aside from that, like you mentioned earlier, they got to have that $46,000 in cash to be able to pay your services as the attorney and the administrator or the executor of the estate, correct?
Correct. So this is if it's probate. Now, we began the conversation with what's the difference between a will and a trust. A trust avoids all that. A trust says, hey, we're not going to court in the first place, family. We're putting the house in this basket. You guys pick it up. You guys sell it. Do whatever you want. Now, it's not free. There's still going to be attorney's fees. It's still going to be something, but it's going to be way cheaper.
Yeah.
Much, much cheaper. 40,000 cheaper, let's say, even more than 45,000. It's being way cheaper. And all the family does is, file an affidavit of death of trustee, sell the house as a trustee, put it in the bank account, split up the money to the kids, get an accounting. There's still work to do. There's still professional services, a CPA, an attorney, a realtor, but you're not paying crazy court costs.
Right.
So, and the court costs, not the court, it's the attorney fees and the personal representative fees. But once you have a trust, and you still have to think, it's still a business decision you have to make. Is it worth keeping the house? Yeah, I didn't have to pay the crazy money, but most people just have it straight in their heads. I'm going to keep the house and rent it out. That may not be as easy as you think, because the property taxes will be so much higher. it's like you're not going to know what hit you.
Yeah. So the only way they avoid the property tax is by moving into it within 12 months
Of the death.
Of the death or the affidavit of death being recorded.
12 months of the date of death.
Okay.
And the county and the state
That's great
is very, very strict about that. I've known of situations where people just didn't tell the county dad died to avoid it. Well, then 15 years later, they got to sell the house, and now they finally file an affidavit of death of trustee because, they can't sell the house in dad's name. Dad died. They finally file it, and guess what the county does? Great. Back tax all at once, 15 years. Pay up. And they slap them with a 15-year back tax.
Wow.
So it's, don't commit fraud on the county. Don't, they will get their money back. You got to tell them right away. And the deadline to move in is 12 months from date of death, not from whenever you get around to filing. Here's the situation, though. What if there's more than one kid?
Oh, yeah.
Right.
Well, and that's most families.
Most families, more than one kid. And now you have that one kid that wants to buy out the siblings. Okay. And move in.
Does he avoid the property tax by doing that?
He can if he does it right. The way to do it right is you cannot get a personal loan and pay off your brother and sister. Because if you do that, it's a transfer from sibling to sibling, and the property tax, let's say there's 3 kids, right? The property tax gets reassessed 66% because only one kid moved in.
Yeah.
Okay. 66% of current market value. Well, that's, if you bought your house in the 80s, 70s, it's going to be, you can add a 0 to your parents' property tax, right?
Right.
10 times more. But the way to do that is you get a special loan as a trustee. You use that trustee loan to pay off the siblings, and then you get a personal loan to pay off the trustee loan.
Okay, right? So you can't just get a regular mortgage.
You can't just get a regular mortgage on your own. No, because the property tax will still go up. There's a way to do it. The county recognizes it, but you have to get a trustee loan. You have to look around. There's not a lot of companies do it. Some do, but you have to look around for a company that's willing to do a trustee loan. Another issue that people often get into in these cases is, why bother? Hey, just add my kid as a joint tenant. I often have clients who say, I don't want to deal with a will, a trust, everything. Just add my kid as a joint tenant. I die, they get the house done. True. They would get the house. If you add your kid as a joint tenant, you don't have to do a will or a trust. They get the house. That is true. Here's what happens. The kid inherits the parent's capital gains tax basis. So they get the house a lot of times with their kids just so they can qualify, right? They buy the house in 1995 with the kid so they can qualify. It's not the kid's house. Nobody thinks of it as the son's house. Parents pay the mortgage all the time. Parents pay the property tax. The son is just there, just in the paperwork. No big deal.
Right, just to get the loan. Just
to get the loan. Well, mom and dad die. Son files an affidavit of death of joint tenant. It's his house. Yeah, no will, no trust needed. True. No court needed. Then son says, in 2025, I'm going to sell the house. Okay, 30 years later. You think the value has gone up at all in 30 years?
Just a bit.
Okay. Son doesn't live there. Remember, it's mom and dad's house. Yeah. He gets to pay 20% of the difference between the purchase price and his sales price.
Wow.
Okay, so if it grew by $800,000, yeah. Okay, he's paying $160,000 in property tax. So, but hey, you know what? He didn't pay his attorney a couple thousand for the trust.
Yeah.
He got to pay $160,000 in capital gains tax.
Wow, that's a lot of money.
Yeah.
And that's because people just want to try to get the loan to buy the home, and they're unaware of how this all works when they transfer the title.
Yeah, they'll add a kid to title thinking it's no big deal. And before 2020, it wasn't a big deal. You could add a kid to title, you could take a kid off title, and nothing happened with property tax. After 2020, if you recall, Prop 19.
Yes.
Okay, that passed in 2020. It came in effect in February 21. And it basically said if a kid is added to title or removed from title, and the kid doesn't live there, only the parents do, property tax goes up. Okay, it's reassessed.
Yeah, it's reassessed.
So I'm seeing in my clients where they added a kid to title 10 years ago. It was fine. They did the right thing. And now one of the parents dies, and now it's son and mom together. Well, what about dad's half? Dad's third? Where did that go? Half to mom. That's not reassessed. It's spouse transfer. But half of dad's half went to son, right? Son went from 33% to 50%. Okay. So now it's reassessed. And I just had a call 3 days ago from a distraught mother. I can't live in this house. I've lived in this house for 35 years. I can't afford to live here anymore. What do I do? Well, I mean, not much. The property tax went up because dad gave his third to son who doesn't live there. Now, had there been enough time, had dad just passed away, I would have said son needs to move in like yesterday. Drop what he's doing, move into your house, stay there, I think, for at least a year. Okay, then you can go back to property tax. But, you have a year. That's a deadline. In this case, it was 2 years anyway. Even if the son could move in, it was too late. And now mom, after buying the house a long time ago, working so hard to keep it, is really having trouble because they did something that was very innocent back then, add kid to title. But the effect of Prop 19 is any transfer.
Yeah. So let me ask you this,
tax.
though. Even though they added him to title to get the loan, if they had a living trust and the property was, the grant deed was under the living trust, could they avoided this situation?
Great question. No. It's still the county will look through the trust. They will request a copy of the trust, and they are the only ones who have the right to the whole trust, right? Everybody else wants to see the trust. I tell my clients, tell them pound sand. It's none of your business. But the county does have a right to the whole trust, not just a certificate of trust. And they want to see who's getting what. So no, in that case, the trust doesn't help. What's really important is don't put your kids on title. If you had to get the loan in the first place, as soon as you can, refinance. Okay, I've had clients who can't refinance. Here's what I encourage them to do in this case. For example, what could they do if they're elderly, they can't refinance, they can't afford another loan. And the son has a third, mom and dad have 2/3. Okay, you split it up from mom and dad and son all as joint tenants to mom and dad as joint tenants as to 2/3, son as to 1/3, and the two groups, the 2/3 and the 1/3, they're tenants in common. They're not joint tenants. Mm-hmm. So that if dad dies, his part goes entirely to mom. Now mom has 2/3, and that's not gift to a spouse. It's not reassessable. Son still has his 1/3. Son does his estate, his own trust on his 1/3. You can do it. It's called a realty trust. It's a trust with nothing else besides your portion of mom and dad's house. Mom and dad do their trust on the 2/3. And let's say they have 3 kids, right? Ideally 3 kids, great. Their only beneficiaries of their trust is the other 2 kids, not the son, because the son already has a third. So that way there's no transfer on somebody's death and it still equalizes. Now, if you have 4 kids and 1 kid on title, it's not going to, somebody's going to get more. This only works if the number's out, not everybody's going to be happy. But what you should not do is be straight up joint tenants with parents and children. If you're stuck in that situation and you can't refinance, at least be tenants in common. See an attorney. Don't do this on your own. But at least be tenants in common with the kid so that between the parents, they can do their own thing and their interest doesn't go to the kid right away.
So, I mean, there's a lot to do with how when you buy a property, how you added the title.
Yes.
Most people just say, hey, it's joint tenants and we're good. But that's not the case from what we're hearing here.
If you're talking about kids added to title, that shouldn't be the case.
Multiple people, let's say 3 brothers buy a home as an investment.
Great question. So if they're not married, anybody who's not married to each other should not be joint tenants, honestly. Mm-hmm. It really should be tenants in common. And the reason is, let's say 3 brothers buy a home as an investment. I've seen that a lot, right? Brother, brother-in-law, sister, and it's just a rental property. Okay, here's what happens. One of them dies. The other 2 absorb that interest, right? Instead of getting 33, now it's 50-50. So each of them got 17% interest from the guy that died. Mm-hmm. Well, unless you're parent-child and you both live there, the property tax goes up. But had they done it as 3 brothers as tenants in common and not as joint tenants, each person that dies has his own will and trust. Now, yes, it will still be reassessed because there's brothers, right? It's going to go to somebody else. It's still going to be reassessed, but they can control it. See, if you're a joint tenancy, your will is irrelevant. Your trust is irrelevant. You can have the fanciest trust, the fanciest will. Joint tenancy trumps it all. Same thing in bank account, right? If your bank account is a joint tenant, nobody's going to care what your trust says. Same thing with life insurance. You got a beneficiary, they don't care what your trust says. That doesn't override.
Right.
You wrote who you want to get it.
Yeah.
So same thing. If you want to be in control of who gets it when you die, do it. Get on title as tenant in common, and then have your own trust.
Right. Okay. So it seems like, I mean, this whole deed situation, we could probably do a whole podcast just on how to write down specifically how you should deed your house to yourself or to your kids, how you should be added the title when you buy a property. So we definitely have to do that one with you. It seems like you're very passionate about that, and I appreciate that, because there's a lot of people, they ask us from the real estate side, hey, like, how should I, write our names down on the deed? And I always tell them that they should talk to their estate planning attorney, because this is, it goes far beyond our expertise as real estate professionals.
I can give you some hints on that, right?
Yeah.
Briefly, a married couple. So let's start with the married couple that buys a house.
Yeah.
The first question I would ask them is the down payment entirely from money earned during the marriage, or did one of you get an inheritance or a gift from mom and dad? If the answer is all the down payment is money earned during marriage. Question number 2, are you going to make the mortgage payments entirely with money earned during the marriage, or is mom and dad going to help one of you out? If none of the above apply, it's the entire down payment is money we earned, and all the mortgage payments are going to be money out of our income. The answer usually, not always, but usually is it's better to get it as community property with right of survivorship. Okay? By state law, it's community property anyway. If it's during their marriage, it doesn't matter if it's only one. A lot of times, only one person will be on title because they have better credit.
Right.
Okay? So they'll get the loan with, husband only on title. That's the case I see a lot. Okay? Great. Get the loan. Get done with escrow, add wife right away. Don't keep her off title. Add wife right away as community property with right of survivorship. There's cases where I don't recommend community property, and it's usually cases where one of the spouses has a job that they're likely to get sued. Right.
Okay.
That they're likely to, a truck driver, a police officer, something where it's a high-risk job. You're in a high-risk industry. It's then community property exposes the entire house, whereas joint tenancy, you might have an argument for you can only get up to half the house. But if, Joe and Mary working at the office, community property.
Wow, that's
It's usually the way to
Yeah.
do it. Community property with right of survivorship, not just community
Yeah,
property.
because most people, when they're married, they just think joint tenancy. But now you're saying community property with right to survivorship.
With right of survivorship is usually better.
Right.
For one, it guarantees a complete step up in basis for the kids. Let me explain what that is briefly. Step up in basis is you buy the house at $500,000. You when you pass away, it's $1.5 million. Okay, it grew by $1 million.
Right.
Okay, the first $500,000 are forgiven in California, but what about the second $500,000? 20% capital gains tax. Ouch.
Yeah.
Your kids would, if there was no step up in basis, your kids would pay $100,000 on the sale of the house in taxes.
Wow.
Before they split it up between themselves. But because of a step up in basis, the value of the house is reassessed instead of $500,000 to $1.5 million. Let's say they sell it 2 months later. Now it's $1.5 million and $10,000. Okay, great. They paid $2,000 in property tax and capital gains tax. Right, 20%. But a community property with right of survivorship guarantees a full step up in basis. Joint tenancy is yes and no. That's more of it depends. So that's why I usually recommend community property with right of survivorship. But again, only if somebody's not a high risk industry, and only if all of the money that came into the house, the down payment, the mortgage, the repairs, everything is money earned during the marriage. None of you got an inheritance or a gift. This is illegal stuff. Yes, ask your attorney, right?
Yeah.
When you're going to do it, ask your attorney. But that's usually how I go about with my clients.
Right. Okay. Wonderful. Well, we definitely got a lot of information on the different kinds of deeds and the importance of a living trust. So always remember, if you're buying a house, talk to an attorney, talk to your estate planning attorney about how to do that. If you don't have one, you can definitely talk to Narcis here. We'll got his information here at the bottom of the screen. Feel free to reach out to him. And to close things out, Narcis, is there anything else that you'd like to talk about in closing with the living trust for the folks watching?
Sure. A living trust is your opportunity to clarify your wishes. It's your opportunity to not only express who gets what, but to express your values. A lot of times people will, hey, I want grandma's wedding ring to go to, this my niece, my daughter. Because otherwise what happens, right? In a probate court, and you know all about estate sales, right?
Yes.
You got to sell everything. You sell the guitar. Oh, but that's Dad's guitar. He used to play, at night. It's sentimental value, and only one kid plays the guitar. So what? We're selling it. You got to sell everything and split the money. Well, really? I mean, most people don't. I want my son who plays the guitar to have it instead of selling it. And everybody. So there's things like that where a trust allows you to express your desires, your values, and family heirlooms, right? A trust allows you to place conditions. That's the other thing about a trust. It's not just, here, money 3 ways done. What if, God forbid, your kid's on drugs? Probate, they're getting the money, right?
Just get split in thirds. If
You're done.
Kids, yeah.
Right, here's your money. He's going to blow it on drugs? Oh, well. No, a trust. My trusts say, hey, if you're on drugs or substance abuse or alcohol, the trustee can withhold the money. So it protects you. What about a kid that gets in an accident and now they're on Medi-Cal or an SSI and they're government help, and they get a huge chunk of change from mom and dad's estate, and they're kicked off of government help. They blow through that in caregivers in 6 months, and now they're poor again with nothing. A trust allows you to also protect the money, also protect you from your kids' creditors. Hey, you worked hard for that house. You worked hard all your life. You don't want it to get sucked off by your kids' credit cards, right? The trust allows your trustee to say to the credit card people going after your kid, sorry, it's not for you. This is mom and dad's money for him, not for you. And so there's so many advantages besides just saying who gets what. There's conditions and protections that you can add with a trust, that you can't with just a will.
What about that? I've heard that within the trust, there's also like a health directive, right? Where you could determine what happens to you if you are in incapacity to make decisions for your health.
Yeah. So as part of a trust packet, it's not part of the trust itself, but it's usually most attorneys have it as part of the packet where there's a trust. Then there's a power of attorney, and there's a healthcare directive.
So that's kind of like the anatomy of a trust. Is you got the financial side, then you can add a health directive to it, and then what was the other one you said?
Power of attorney.
Power of attorney.
Yeah. Briefly, a trust. Here's a big difference between a trust and a will. A will is useless until you die. It has no authority. A trust, the trustee becomes a trustee when you get sick. If you're alive but sick and can't handle your finances, that's when the trustee comes into play. Okay. Power of attorney, somebody can sign for you legal documents. And then a healthcare directive. This is really important if you have more than one child, right? Let's say you're widower, and now it's just the kids. Well, who's in charge of the hospital? Answer, all of them. Well, good luck being the doctor figuring that one out if the kids disagree.
Right.
But an advanced healthcare directive, you get to say which kid you trust to make decisions, and you get to say who's in charge. And that's super important. There's another document that I usually do. It's called the final disposition. Who's in charge of burial or cremation? I had a family call me a few months ago. Hey, my dad wanted to be buried in Mexico. No, he wanted to be buried here. Well, you guys all have authority. You guys got to work it out. None of you can tell the coroner what to do and where to take the body because all of you have authority. You guys better work it out. Whereas if you have a final disposition, you get to say who's in charge.
Right. So it's very important to have a living trust, and it is, as a whole, it doesn't just protect the assets in the house. It also gives direction to everything else once you pass away.
Yeah, it's a living trust packet. The trust, the power of attorney, advanced healthcare directive, and the final disposition. Of course, deeds to the trust. It's very important to do this, and a lot of times you'll see I can do this on LegalZoom, RocketLawyer.com.
That's what I was going to ask you. What's the difference of doing it on LegalZoom or hiring an attorney?
Two things. The example I like to give is, why see a doctor when you just go on WebMD? Diagnose yourself, WebMD, click, done. I don't have the medication. I don't know, get them from another country. because you're your own attorney when you do that. You just click the buttons. You are your own attorney, and it's about as smart as being your own doctor.
Yeah, and then you don't get the advice of how to, put your name on the deed and everything, and it's going to be the living trust, though.
Yeah.
So you don't get direction on all that. So that's what's important. So definitely reach out to an attorney when you're doing a living trust. And I think that's all we got time for right
All
now.
right. Thank you for your time.
You're off to an appointment. So thank you for watching, everyone. And if you have any questions on the legal matters of estate planning or probate, you got Narcis here that you can call. And if you have any questions on real estate related topics that have to do with probate or trust inheritance, you can always call me, Marcos Orozco. My phone number is down below, and I'm with Probate and Trust Realty Group. Thank you for watching.
Thank you.